All right. In our earlier lecture, we focused more on Stockholm Declaration on Environment. This session, we will focus more on the Indian laws on environment. Actually, a quick survey of the environmental legislations enacted prior to our independence show that there had at least been 5 major legislations. Some applies to specific areas, but that's not the issue. But it is all over India actually. 5 legislations have been made for protecting environment. One is, very interestingly, dates back to 1853. Shore Nuisance Act, Bombay and Colaba area. That's the first of the legislations. You must know, much of Bombay is a reclaimed city, but Shore Nuisance Act is a very important development. Then Bengal Smoke Nuisance Act, 1905. Please remember that Stockholm Declaration has identified heat to be one of the pollutants actually. Heat is also a pollutant. Heat is a pollutant, smoke is a pollutant. 1905 Bengal law. Bombay Smoke Nuisance Act, 1912, within 7 years, These two cities were the most industrialized cities in India then, and both of them have had a legislation in place to handle that. Fisheries Act, 1897. Wild Birds and Animal Protection Act, 1912. Actually, I must add a word about the Fisheries Act, 1897. See, surprisingly, India has naturally amongst one of the biggest, it has one of the biggest coastlines. It has a lot of people involved in catching fish. I'm talking about both marine fishermen and inland fishermen. But if you compare the productivity of an Indian fisherman, say with that of a Scandinavian, Japanese, or even a British fisherman, our productivity levels are not very good. I mean, that's a different issue. In a way, it is good. We'll not go into that. And the Wild Birds and Animal Protection Act, 1912. So you have, even before independence, at least 5 legislations to govern environment, and it shows that we were not totally oblivious to the issue of protection of environment. I mean, you should give credit to British for that actually. Okay. Now, having said that, the most of the international law as we understand today is contained in 4 general legislations and at least 8 other special legislations. What are the 4 general legislation? Air Prevention and Control of Pollution Act, 1981. Prevention of Air and Water Pollution Act, 1974. Forest Conservation Act, 1980. Environmental Protection Act, 1986. And thereafter, you had this Environmental Conservation Act, 1989. National Environmental Tribunal, by an act, it's an administrative tribunal, was constituted in 1995. Then, National Environmental Appellate Authority Act, 1997, actually, okay. After there is no appeal to the High Court. Matters arising from Green Tribunal. You have to appeal to the National Environmental Tribunal Act, Appellate Authority, and then it goes to the Supreme Court under SLP. Then, National Environmental Management Act, 1998. Biological Diversity Act, 2002. So, these 9 legislations constitute the bulwark of the Indian laws relating to environment. Okay. Actually, I must tell you that rules play a more important role in the environmental advocacy. Act is passed by the parliament. Rules, ordinances, notifications, they are all made by the government. In administrative legal parlance, we call this as delegated legislation. It is not the main business of the executive to make law. Executive is supposed to implement the law. But the legislature is too busy, you please understand that Indian Parliament meets only for about 3.5 months for the whole year. And if you look at the number of working days, 3.5 months is 140 days, they may probably work for about 70 to 90 days. And in the 70 to 90 days, these guys will come to the well, boycott, there will be reference for the departed parliamentarians, and if you cut out all that, they really have no time to debate on legal issues actually. And you must understand that all governments, most important legislative changes, they bring it by an ordinance, and that ordinance is ratified by the both Lok Sabha and Rajya Sabha. And that was the situation in the Jammu and Kashmir Reorganization Act, and that is the situation in the recent farmers bill which have been passed as ordinances actually. Actually, it is not the best and ideal way. We got to concede that. There must be a recent debate on both the houses of the parliament before a law comes into existence. It has actually the primary job is that of the legislature. A legislature is probably more interested in more lucrative matters. They have no time for technical matters. They have neither time nor inclination to apply their mind to pressing principles, and they would rather allow the bureaucrat to take the decision and give a rubber stamp kind of, okay, in many ways it may not be a bad idea because the bureaucrats are probably better equipped to understand the situation in hand than the legislature themselves because they are more focused and they get all the relevant information. Now, why I am saying all this is that lots of Indian environmental law is contained in this delegated legislation. Number 1, Handling and Management of Hazardous Waste Rules, 1989. Public Liability Insurance Act and Rules, 1992. Biomedical Waste Management Handling Rules, 1998. Environment, Siting for Industrial Project Rules, 1999. Municipal Soil Waste Management and Handling Rules, 2000. Zone Depleting Substances Order, 2002. Actually, if you look at it, in law there are two types of legislations. One is the general legislation and the other is the special legislation. And you find in this scenario, all the general legislations have been passed by the parliament. All the special legislations, which are to be passed by the parliament normally is made by this is what you call, there has been a lot of jurisprudential talk on the undesirability of rule by ordinances actually. In other words, we are having a law that is going to govern us, which is not exactly made by the legislature or parliament, which is supreme, which has all the right to make the law under the Indian Constitution. We will be governed by laws which are made by the executive. All right. Now, having given you this basic framework of the legislations, let us go to specific cases. Actually, as a law teacher, I had an opportunity to consider the impact of Bhopal litigation on Indian tort law. We all know that Bhopal tragedy is very sad. Probably there were design faults. If you ask me, what is the design fault? The most poisonous gas which was involved is methyl isocyanate. This methyl isocyanate was actually used for making a very important branded fertilizer, pesticide. I don't remember the name. Maybe I'll get it and I'll tell you later. Now, the Canadian environmental authorities, this pesticide was first manufactured by Union Carbide in the Canada plant actually. Okay, it was not even made in USA. It was made in Canada and supplied to USA and to the rest of the world actually. The Canadian environmental authorities raised an objection that this is a very poisonous gas and you should not store them in such huge quantities. And as and when the gas is made, convert it into a pesticide so that there is no need for you to store this gas in huge quantities. They couldn't do that. They thought if they shift the plant to somewhere else, they could continue with the old process of storing and making the pesticide out of it. Actually, they tried to shift the manufacturing of this methyl isocyanate to France. Union Carbide tried that. France said that, look here, come on, Canada says that, it cannot be stored, okay? You make the pesticide as soon as the methyl isocyanate is made. Then why do you want to give me that plant which will involve storing huge quantities of methyl isocyanate? Well, they came to India. For whatever reason, I'm sure that in India we are, it's okay, chalta hai, Ram Ram Satya hai, and if something is destined to happen, it will happen, okay. Probably that was the attitude. And this plant has worked perfectly fine in Canada, and why bother about this? And they granted the license. Please remember, Union Carbide plant, one of the senior Mahindra, okay, not the present Anand Mahindra, I think it's Keshav Mahindra if I am not mistaken. He was the chairman and managing director of Union Carbide India Limited, not somebody who is known to be an irresponsible capitalist like Arshad Mehta or anybody else, okay. He comes from a responsible family, pedigree is impeccable, professionally managed, everything good about that. There was a lockdown and there must be a cooling system. And due to the power cut and maintenance difficulties, the cooling system did not work. The methyl isocyanate got into a very big chain reaction. Good lot of it escaped. What are the consequences? Something like 4,000 to 6,000 deaths immediately, 10,000 to 12,000 deaths delayed later on, 30,000 to 40,000 cases of partial blindness, okay. Thousands of cattle perished. In fact, some people who were traveling by a train, which is adjacent to the Union Carbide factory, suffered breathlessness, injuries, etc., etc. It was terrible. Okay. This case exposed a lot of inadequacies in the Indian justice administration system, more particularly compensating victims of tort. This is another side story which we have to talk about that. Earlier I told you in my class, for us the law of environment simply means law relating to nuisance, negligence, strict liability and of late absolute liability. Beyond that we never thought of anything. Maybe they would have got away with that if you go by all these traditional defenses available to strict liability or nuisance actually, because it's a statutory authority, but there was negligence, let's accept that. Now, let's come to the matter. There was a settlement. Okay. Supreme Court quashed the penal liability of the directors, particularly the Union Carbide Corporation Danbury director. I think his name was Anderson. He was arrested, he was released on bail, and he was escorted out of India, and he never came to India. Government of India never initiated extradition proceedings. Now, the Mahindra was prosecuted, he was convicted. I think the Supreme Court upheld the conviction, but he never went to jail even for a single day. I am not here to say that he ought to have gone to the jail, but I do think that Mr. Anderson ought to have been prosecuted in the American courts for negligent manslaughter. We don't want, anyway, that is a side story. Now, and please remember, the financial, now Union Carbide has divested. They divested Eveready, Eveready became a separate company. It is still a listed company and it is a good buy in the stock market. But Union Carbide does not anymore exist actually, okay. They went into liquidation, Union Carbide India Limited. So the point I am trying to impress upon here is contrast it with the oil leak, Exxon Valdez, off the coast of British Columbia in Canada. Okay. Canadian Arctic Pollution Act. This is the applicable legislation. There is a Exxon company's shipping tanker, Valdez, hit a reef like the Titanic or whatever, and it started leaking oil, and almost the entire oil got leaked, and sub-zero conditions. So the oil didn't disintegrate. It killed a lot of seagulls, polar bear, marine plankton, fisheries, and Government of Canada spent a lot of money on it. Luckily, the cleanup was not so difficult because of the sub-zero temperature conditions. And believe me, for this, Exxon Corporation paid something like $10 billion in cleanup cost. No human died, mind you. Polar bears, seagulls, marine plankton, fisheries. You appreciate that the value of these, non-humans are much more than the 15,000 dead, the 20,000 blinded, 2 lakh permanently disabled, 50,000 cattle in India perishing. Well, it somehow tells you the imbalances in the seriousness of the implementation of environmental law. All right. Let me very quickly talk to you about a few cases. MC Mehta versus Union of India. He has filed a lot of cases, and whenever you mention an MC Mehta case, please do mention which case is it actually, because there is one DCM, oleum, gas leak case, and there are lots of cases, and I am going to talk to you about that also. MC Mehta case is a funny case actually. I would always call it a dubious precedent, as an academic lawyer. There are two ways of deciding the ratio decidendi in a case. One is a Goodhart test and the other is the Bamboos test actually. People who are familiar with legal methods and jurisprudence, please do Google and find out for yourself what is ratio decidendi and how to find out the ratio decidendi. These are the two tests, Goodhart test and Bamboos test. Actually, if you go by the strict principles of jurisprudence, MC Mehta case is a very, very dubious precedent. But believe me, it has achieved national and international respectability. First, oleum gas leaked from DCM factory. I think there was about 1 or 2 deaths and a few people fainted. and the matter was taken up before the Supreme Court in a public interest litigation. DCM said, hey, look here, you are filing a writ against me, I am a private individual. Okay, I am a company, I am not an instrumentality of a state. Whether a writ would lie against a private company, that was one question. Two, assuming that I have to pay compensation for the negligence or nuisance of the leak of gases, should it be in a civil trial or in a writ petition? 3. Can it be an interim compensation even before the issue of liability is finally decided? These are three important legal issues, but Supreme Court sidestepped all three. They said, look, when it is the right to life is involved, very simple. It will be available even against private individuals. For example, habeas corpus can be got against the father who is detaining his major daughter who is above the prescribed age. That can lie. So, there can be a writ even against a private individual when it comes to personal liberty. Right to clean environment is part of personal liberty. That they said. 3. In all pollution related matter, after Stockholm Declaration, the law is polluter pays. You don't have any defenses at all, okay? Somebody suffered damage and the damage is because of the pollution caused by you. So, the doctrine of absolute liability was established in DCM oleum gas case MC Mehta versus Union of India, and it has substantially changed the position of the Ryland versus Fletcher, where they said strict liability. And there are so many good defenses against strict liability that over a period of time, the strict liability became not all that strict actually. Okay, it was cool. Probably negligence and nuisance saved the claimant than the principle of strict liability. So a new law came into being called absolute liability, and it is now become the order of the day. Then next is Sardar Sarovar case actually. You must know Medha Patkar. I mean, I have always followed her with great interest. Sardar Sarovar is a very interesting project. It is one of the first successful cases of three inter-basin states collaborating and coming up with a project. Now, Sardar Sarovar was to be constructed in Madhya Pradesh, okay. Probably in Maharashtra, not Madhya Pradesh, Maharashtra border, but most of the water catchment and the submergence area would be in Madhya Pradesh. And that place was inhabited by a lot of tribal community, marginalized people. Maharashtra will also be a beneficiary, but not much of benefit for Bhopal. Madhya Pradesh, we have to accept that. Gujarat is the biggest beneficiary of the project. Originally, they were supposed to finance it with the help from the World Bank. But World Bank had put in place very tough norms to ensure rehabilitation of the displaced people from a project. But these conditionalities were so difficult for Government of India. Later on, they forewent World Bank loan and completed the projects, out of their own funds actually. Now, finally, the Supreme Court said that, look here, it's a very difficult choice. Madhya Pradesh tribals were affected. Maharashtra stand to benefit a lot. Gujarat benefited a lot. And Madhya Pradesh government was compensated in terms of money and some power and a lot of other things, and but it is one of the classic cases of interstate cooperation. And please remember, if you look at the availability of the per capita water availability in India, considering that our population has tripled in the last 70 years, and considering further, as your standard of living increases, your demand for fresh water consumption also increases. So unless you have the, what do you call, capabilities to impound the water which otherwise flows into the sea, you are not going to meet your water needs. The Supreme Court said, okay, it's a tough choice, but nevertheless, we have to let it go. That's all. Then the second is the MC Mehta's Taj Mahal case. I think I mentioned just now that MC Mehta has filed a lot of cases. Taj Mahal, Agra area, had a lot of foundries. Okay, iron melting, copper melting, etc., etc. Second is they also had a very flourishing dur dal polishing industry. And both of them used a lot of coal. You understand? And plus, Bharat Refineries, BPCL, which is subsequently taken over by Reliance, they had the Mathura oil refinery. Oil refinery also releases a lot of hydrogen sulfide, sulfur dioxide, and these foundries have been releasing a lot of carbon dioxide, sulfur dioxide. So the government compelled all the foundries to switch over to more environmentally friendly methods like gas burners and electricity. And still the Mathura refinery continues to pollute the Taj. And the condition of Taj ultimately is, okay, this is the second. And yet another case is a very interesting case in 1996, that is that of the Kamala Caves. Kamala, is the chief minister who was recently displaced in Bhopal. And, he's a smart guy, obviously, he's a person who can give Jyotiraditya Scindia a run for his money, okay. But still, he owned a resort, and to ensure that the resort has a lake bank or the river bank, he diverted the course of a river actually. Which is a blatant abuse of authority, and you couldn't have done it except for the connivance of the PWD and the Forest Department blokes in the state of Madhya Pradesh. But then he was also the Minister for Environment at some point of time, right? So no big deal. So he had these cases, and finally, he had to remove all the unlawful construction and to restore the original course of the river. God alone knows how much was done, but nevertheless, that was considered to be a rap on the knuckles of Kamal Nath, and there ends the matter actually. Whoever, even if he was very powerful, I think the environmental lobby could say that they have made a victory. A lot of issues, even in Tamil Nadu, the Madras floods, which is about 5 years ago, a hospital had come up, and that hospital, I have 2 more cases to discuss, and if I do that, we finish the class actually. Okay. First is this Kochi building demolition case. The Maradu municipality in Kerala permitted a building construction plan totally in violation of the Coastal Zone Regulation Act. They say something like 500 meters from the high water tide, there should not be any construction. And any project above 100 crores must have environmental impact assessment. These guys, the municipality, not the municipality, in these cases panchayats actually, permitted multi-storied buildings exceeding 100 crores without environmental impact assessment, and Golden Kailoram, Jain, Church, a lot of people who are considered to be pious, were involved in this project. Everybody, the builders made the money and they sold it to people for prices ranging from 1.5 crores to 2 crores, etc. In fact, even lawyers made their investment on that, and later it turned out that this is an illegal building and they ought not to have granted building plan sanction at all. The Supreme Court, Justice Arun Mishra, demanded that this building is demolished forthwith. And these people were given a compensation of about 25,000, and the government was asked to pay the compensation and then recover it from the builders actually. Okay, government paid it. Because they said it is the government which has allowed these constructions to come up. You knew all the law. And similarly, you have the case of this Adarsh Housing Cooperative Society in Bombay. There are also a lot of violation, but the difference is most of the people who had bought the plots in Adarsh were bureaucrats who had power in the Maharashtra, and I'm sure the case is still pending, and hopefully either they get it or they'll get it regularized after a fine, or their buildings also will go like the Kerala buildings, God alone will say. But I would say unlikely, because in India, the law depends on the persons, unfortunately. I mean, that is why I quoted the Kamal case also, to show that sometimes, however big you are, you may have to pay the price. And that's what exactly happened in Kamal case, and that's what happened in the Kerala buildings demolition case. Okay. No environmental jurisprudence in India is complete without mentioning the case of Vardi Chand versus Ratlam municipality. Okay, this is a 1981 case decided by Justice Krishna Iyer. Okay, it is a case where whenever there is a public nuisance, the deputy commissioner should be directed to remove the public nuisance. This case, the public nuisance was perpetuated by the Ratlam municipality. It did not remove the waste from the market area. Now it is charging the market people and the people of the locality money for it. So there is a public nuisance, and the deputy commissioner directed the municipality to remove the public nuisance. And they should have removed it. It wouldn't have cost money. They went on appeal to the Madhya Pradesh High Court. Madhya Pradesh High Court said the deputy commissioner is correct, you bloody well remove the nuisance. You are duty bound. But they went to Supreme Court. Krishna Iyer got livid. Man, you must have paid, lakhs of rupees to engage top lawyers to argue the cases. If we had put the same amount of money for cleaning up the mess, the country would be better off. So, even public authorities have been held guilty of public nuisance, and they were directed to remove the public nuisance. The next important development in India is the National Green Tribunal Act. I mentioned to you about the 8 legislations. In respect of these 8 legislations, they have total and compulsory jurisdiction. Even compensation claims arising under these 8 legislations have to be necessarily tried in the National Green Tribunal. And actually, the period of limitation is less. Okay. It's about a year and 6 months, when the general law is about 3 years. I think the Green Tribunal is making right noises, one has to really wait and see. Actually, it's an administrative tribunal. How well the administrative tribunal functions, we have to wait and see after a period of 10 years actually. Okay, so I would still say that NGT is still under probation. If you go by the record of the Interstate River Water Tribunals Act, not anything extraordinary, but the Central Administrative Tribunal, neither this way nor that way. Appellate, Direct Access Appellate Tribunal, fairly credible, So you have different gradations, and you have to exactly see how exactly the Green Tribunal is going to shape the environmental jurisprudence in India. Thank you very much for being with us, and if you have any comments or questions or content improvement, or even you want the lecture notes for the lecture, please get back to us, and don't forget to subscribe our channel. Thank you very, very much.